going to get right into it because I think we have a great set of back-to-back panels here that you're really going to enjoy. This first one is going to set the table a little bit as to things we discussed yesterday and we're going to follow up on, which were, of course, all this burden, all this process. Where are the results, and why don't we have those results? So we're going to kick it off with that, and then right after is the famous Examine the Regulators panel, where we're going to follow up with them and see what their thoughts are on what this opening panel has to say, and ask them if they would agree that there's too much process and not enough in the area of results. So I'm going to turn it over to our moderator, Les Joseph from Wells Fargo.
Good morning. Thank you, David. It's great to be back here at FIBA. I think yesterday was a great day, and I hope that we can kick off another great day with our discussion this morning. For the past several years, when I have moderated this global AML exchange panel, I've tried to bring together speakers from different countries to discuss AML and financial crimes developments in other parts of the world. This year, as a result of some things that occurred over the summer, I asked David if I could do something a little different. I told David that I was frustrated after being in the AML world for almost 30 years, that despite all of the efforts of government, our regulators, our great law enforcement agencies, all of you in the banking community, and of course all of our wonderful consultants, it was still pretty easy to launder large amounts of money and criminal proceeds around the world. And then I wanted to explore that issue with some AML experts. So David agreed with the idea, and I assembled the experts for this panel. We have on my immediate left Richard Gordon, Professor Richard Gordon from Case Western University Law School. On the far end, Nick Maxwell from the Future of Financial Intelligence Sharing, who, for those of you who were at the Monday session, was there. And in the middle, John Roth, a former DOJ official and a Homeland Security official who is now the Chief Compliance Officer at Bittrex. Could I have the PowerPoint slides, or do I control it? Okay. And notably, each of these experts has written on the topic of money laundering. So Richard Gordon, back in 2011, wrote a paper on losing the war against dirty money, rethinking global standards on preventing money laundering and terrorist financing. Nick, as everyone probably knows, recently was a co-author of a paper on information sharing. And John Roth and I, back in 2007, when we were both together at the Department of Justice, wrote an article about the criminal prosecution of banks under the Bank Secrecy Act. But before we get to this distinguished panel, I'd like to spend a few minutes discussing the events that influenced me over the summer. The first event was the announcement of a civil forfeiture complaint filed by the Department of Justice on July 14, 2017. The civil forfeiture complaint was seeking the forfeiture of numerous assets in the UK and US, including several pieces of real estate and a huge yacht that I believe is almost as big as David's. The forfeitures, you'll see it in a minute, David. The forfeitures were based on a corruption scheme whereby two Nigerian businessmen conspired with others to pay bribes to Nigeria's foreign minister of petroleum, Diezani Alison Madueke. In return for these benefits and payments, Alison Madueke used her influence to steer lucrative oil contracts to companies owned by Nigerian businessmen Mr. Oluko and Mr. Omakore. So what struck me about this case is that it involved a substantial amount of corruption in a country that is unfortunately known for corruption, and I don't mean to disparage Nigeria, but it rates very high on most indices of corruption. So that is kind of a red flag there when you're dealing with large amounts of money. And more disturbingly, It involved the purchase of some very high-profile assets in the US and the UK. I commend the Department of Justice for their work in this case. The civil forfeiture complaint provided a lot of detail about the transactions, and one of my talented team members at Wells Fargo, who's an expert in real estate transactions, did a lot of research on the assets involved in this case. And it's clear when you look at all the information that the transactions involved mainstream banks, major law firms, well-known real estate companies, and large title companies. So, for example, the complaint sought the forfeiture of 4 pieces of real estate in the London area totaling 11 million pounds, including this beautiful house that was purchased for 3.2 million pounds for the benefit of Minister Alison Madueke, who was the only person that occupied this house. Another property subject to forfeiture is a very high-profile apartment on West 57th Street in New York, known sometimes as Billionaires Row, that was purchased for $50 million. A prominent law firm and company were involved in this transaction. I could name them, but I won't do that here. Then there was this beautiful property that was purchased in California for a mere $25 million, paid for by 2 wires from Aluco's Swiss bank account to the account of a title company. Now, I have another version of this presentation I could spend an hour or 2 on, and I actually have a picture of the realtor who was involved in this transaction, but I don't want to cause any problems, so I won't show it here. But if you figure 5 or 6% of $25 million, she made a nice commission of over $1 million on this transaction. Incidentally, she has no requirement to do customer due diligence or file suspicious activity reports. Now here's the yacht, David. Is that as big as yours? So also the government is seeking the forfeiture of this beautiful $82 million yacht known as the Galactica Star, which was incidentally purchased in the name of a Mossack Fonseca shell company that was owned by Mr. Aluco. So by the nature of these high-profile assets, it's clear that the perpetrators of this scheme did not care about maintaining a low profile. They flaunted the assets that they purchased, and in fact, the Galactica Star was chartered by Jay-Z and Beyonce for $900,000 for a week to celebrate Beyonce's birthday in 2015. So as I read over this civil forfeiture complaint, I became angry that these corrupt people could launder their money so easily and so flagrantly. And then, about a month later, an organization called FACT Coalition, which is Financial Accountability and Corporate Transparency, published a report authored by John Cassara entitled Countering International Money Laundering, Total Failure is Only a Decimal Point Away. John, incidentally, was invited to participate today, but for some reason he thought it was more important to be around his home for the birth of his first grandchild, which is due any day. So I guess that's a good excuse. But John, the report is very interesting. Here are some of the conclusions of the report. According to the UNODC, less than 1% of global illicit financial flows are seized and forfeited, and information suggests that money launderers face a less than 5% risk of conviction in the United States, and the situation in most areas of the world is even worse. No, I'm not saying I don't know where these statistics came from. I'm not saying I agree with all of the findings or conclusions of this report, but it certainly points a sobering picture. So, in any case, while we collectively have taken a lot of good steps to make it harder to launder money and to strengthen our banking system, when I had a discussion with Richard, I was completely despondent, and he said, it's not that bad, Les, we have made progress. Things are better than they were, which is clearly true, but we still have a long ways to go. And this is despite numerous laws that have been enacted and initiatives that have been undertaken over the past 30 years. So, for example, the first major step was the passage of the Bank Secrecy Act in 1970. In 1986, the U.S. enacted its first money laundering statutes. In 1989, the G7 created the Financial Action Task Force, which has done tremendous work in raising the standards of anti-money laundering around the world. And in 2001, we have the USA Patriot Act. But despite all of these efforts, there's still a lot of shortcomings. So this panel got together as we formed and developed a list of some obstacles that we've identified that are contributing to our inability to stem the flow of illegal proceeds. And we're going to go through this list and spend a few minutes discussing each of these obstacles and why it's so hard to overcome them. And at the end, we'll spend a few minutes discussing some of the steps that can be taken to help us overcome these obstacles. And then, as I was lying in bed this morning at 5 o'clock, thinking about the panel, I realized that I had left something out on this list. I realized I had not included bad banks on the list. I can't imagine why I would have forgotten this, not that I work for a big bank, but clearly they should have been on the list. I didn't want to send Andrea a new PowerPoint at 6 this morning because she would have been very unhappy with me, so I left it off the list. But clearly, major money laundering cases involve, such as the Nigerian case, involve a bank, at least one bank, with a bad compliance culture, or a bank that decided to look the other way in doing certain business transactions. John Roth and I prosecuted a bunch of these banks when we were together at the Department of Justice. And Bob Targ raised this in a session on the NTR Metals case yesterday when he said, obviously, with the volume of $3.6 billion, I think, in transactions involving the gold trade, that banks were obviously involved. They may or may not have filed SARs and cooperated with law enforcement, but in any case, the money moved through banks. So in the Nigerian case, some banks opened accounts for some of these people or the entities they formed when maybe they should not have. And of course, once you get into the banking system, especially with the use of shell companies, it's a lot easier to move your money around. So clearly, banks with weak or ineffective compliance programs are part of the problem, and we together must address that issue as we are every day and every year when we get together here. But now let's go on to the rest of the list. A major contributor to the money laundering problems is political corruption, and I'll let John Roth kick that discussion off.
Thanks, Les. I appreciate the introduction, and thanks to FIBA, by the way, for inviting me here, and thanks to you for inviting me here. I'd like to set the stage for talking about corruption by looking back a little bit at my history. I started doing serious anti-money laundering prosecutions for the U.S. Department of Justice when I came up to Washington, D.C. in about 1994, and really started focusing on what I would call grand corruption in about 96 or 97. And the theme that I've found is that everything that is old is new again. Because when I started doing this seriously, the big money laundering case was, of course, the Raul Salinas case, Citibank, the Mexico brother of the Mexican president, who was involved in the private banking issue up in New York with Citibank. And when I took over what was then the asset forfeiture and money laundering section of the Department of Justice, which is now the better named money laundering and asset recovery section, I took a look at the inventory of cases that we had with regard to asset recovery from corrupt foreign individuals. We had a case out of Peru involving Montesinos. We had a case out of Nigeria involved with Abacha. From the Ukraine, we had the Lazarenko case. And then we prosecuted as well the individuals responsible for the Riggs Bank issues that had money laundering through Pinochet as well as Obiang from Equatorial Guinea. Those were all cases that we did in the early 2000s. And then I sort of moved to more of an international focus. I was the US rep to the Financial Action Task Force, part of the DOJ team there. And there was a huge focus then on corruption. From 2010 to 2014, we really focused on corruption. There were typology papers that were written, and in fact, if anybody's interested in sort of taking a look at the history of corruption as it relates to money laundering, there's a great report in 2011, Laundering the Proceeds of Corruption, that FATF put out. But they put out guidance to member countries. They rewrote the FATF recommendations with regard to politically exposed persons. They had expert meetings. They had public pronouncements by the G20 and others. And then I left the money laundering area for about 6 years and focused on domestic anti-corruption work for the Department of Justice and the Department of Homeland Security. And only in the last few months did I come back to this space. So the first thing I did, of course, was take a look at what has changed in this area with regard to corruption and corruption-related money laundering. And I'm a cynic by nature, but even a cynic like me was shocked at the fact that there hasn't been any improvement. From 1996 to now, it appears to be the Groundhog's Day, the same program being placed over and over again. And I mean, what are the risks here? Obviously, for grand corruption, that is corruption by the individuals who run the country, there is the dual risk of one, having access to significant amounts of illicit proceeds, but two, being able to co-opt the entire financial system of a country. And as Les noted, once you're inside that financial system, particularly with the kinds of shell companies and those kinds of things, it's very, very difficult to move from that. So that's been my experience in the anti-money laundering area. That is, like, everything old is new again. And you know, in 2002 and 2003, we were prosecuting corrupt government officials all over the globe, and apparently in 2017 and 2018, we're continuing to do the same thing without much change, as far as I can tell.
So John, how does that impact the fight against money laundering when we have these corrupt regimes around the world?
Well, I mean, there's a lot of good academic literature on why it is that we shouldn't be allowing corrupt money laundering, how it has a disincentive. You can look at the case of Equatorial Guinea, for example. Per person, it's one of the richest countries in the world if you simply looked at their domestic national product and divided it by the number of people. And yet, if you go there, you realize the crushing poverty that is there. So international corruption, just from a humanitarian point of view, is a significant problem. And it's also destabilizing, I think, all sorts of different markets. For example, the real estate market in various places destabilizes that. And it just runs counter to everything that, you know, as a group of institutions we believe in with regard to a fair process in a democratic society.
Richard, yeah?
I just want to say one thing. When I was also, when I was at the IMF and I was involved with the Financial Action Task Force and was the IMF representative there in the discussions about adopting what then became Recommendation 6, I think is now Recommendation 11, on politically exposed persons, I opposed that term. I said in the United States, to be an exposed person, you just don't want to use that term, but I didn't prevail.
So clearly international corruption is an issue that is preventing certain countries, certain parts of the world from taking effective measures against money laundering, and it's a huge obstacle, obviously not one that we have much control over other than prosecutions like the one I just cited by the Department of Justice to try and crack down on this foreign corruption. Another issue we identified is the lack of political will by certain countries to address the issue, which may or may not tie in with the corruption aspect, or there may be other reasons for that. But John, you want to kick off that discussion as well?
Well, I mean, and that's an interesting area, right? Because we call it lack of political will, but some people dress it up in a different way. I mean, you can have a country that has chosen for a lot of reasons to think that, for example, bank privacy supersedes the ability to sort of investigate the illicit transfer of stolen funds, for example. Or you could think of it rather than privacy as in sort of a nationalism or sovereignty that restricts the ability of countries or institutions within countries to share information. I like to say that we are in a 21st century economic system governed by 19th century laws with regard to exchange of information. And some of this is, frankly, a race to the bottom. In the United States, you can see that, and I know we're going to be talking about sort of corporate formation and the various states and how it is that they do it. But in some ways, it's a race to the bottom. There isn't a will to tackle the problem, and it's to states and countries' economic benefit to actually continue it.
Nick, you raised the issue of resources for enforcement in connection with the lack of political will. How does that tie in?
Yeah, absolutely. So where is the enforcement? I think if just building from John's points about the lack of progress on anti-corruption, the OECD Convention against Bribery, recently celebrated its 20th anniversary. So for 20 years, there's been an international convention for foreign bribery. And on that 20th anniversary, only 4 countries out of the 40-plus signatories were rated by the OECD and Transparency International, who I worked for at the time, as active enforcers of that convention. So a convention 20 years old, and only 4 countries of the signatories actively enforcing that convention. So it's a huge challenge. That means the remainder, which was about 3/4 of world trade, had legislation on paper, in some cases not even that, but it didn't mean that enforcement was there for their commitment under the convention. So real challenges. I think it's difficult if we kind of expand out beyond anti-corruption to financial crime more broadly. In many cases, it's really difficult to get governments to commit to resource their law enforcement efforts on complex financial crime, white-collar crime. Obviously, in many ways, the United States has led the way, but it took the United States some time to get the enforcement capacity there. We saw on the slides one of the pieces of legislation that wasn't there actually was the Foreign and Corrupt Practices Act. That came in the 1970s, but it took a long time for prosecutions to come through. These investigations are very, very complex by nature. It takes real specialist skills within law enforcement, and it takes real commitment to resource that. Politically, it can be a quite difficult thing to commit to. From a public point of view, there can sometimes be an impression that this white-collar crime, some financial crimes, money laundering, can be victimless. It doesn't potentially touch voters in the same way that other law enforcement priorities do, and therefore at the political podium it can be somewhat removed from a voter's concern. What we've seen though, with the emphasis on effectiveness, where the FATF evaluations are currently focused, is that it's brought to light some of the bottlenecks in the system. So we have this huge architecture now created by FATF, the regulatory system, to create your resource, to signal to all of the private sector entities for the FATF countries that they need to invest in identifying, reporting suspicions of financial crime. And we'll talk a little bit more about public-private partnerships later on. But there's been a real growth in the ability of the private sector to provide really high-quality intelligence reports that respond to law enforcement interest, a level of detail and indications of suspicion that law enforcement, in theory, should be able to take on. But the fact is, in even the most advanced financial centers, the amount of intelligence that's there that indicates financial crime, the amount of suspicious activity reports, far exceeds the law enforcement capacity to take that forward to prosecution. So we have this huge imbalance hardwired into the system, where if we think about the expense in the private sector for developing what we might consider intelligence for law enforcement leads to lead investigations, there's such a small bandwidth for law enforcement to take on that reporting, to take on that intelligence to investigations and prosecution. So the resource spent on the intelligence collection side, if we consider the private sector reporting within that, absolutely dwarfs the resource available for law enforcement prosecutions. In the UK, it's estimated that about 5 billion is spent on, and this is a conservative estimate, $5 billion is spent on compliance for financial crime and suspicious activity reporting. We have a larger number of sectors that are covered by anti-money laundering reporting obligations. But even the entire budget of our National Crime Agency, which is not only the FIU receiving all those suspicious activity reports, but it's also the lead enforcement agency for all of our complex and serious crimes. The budget's $500 million. So 20 times the resource, even at a conservative estimate, is going into feeding the law enforcement machine with intelligence. But is the resource there really to prosecute and take forward these very, very difficult, complex and lengthy investigations? Even in the most advanced jurisdictions, countries are struggling.
Thanks, Nick. I think the point about the FATF emphasis on effectiveness in their evaluations now is an important one, because you can have a great regime of laws in place, but if you only have 2 prosecutors or 2 investigators, or they're not trained, then obviously you're not going to be effective. And I think the same applies to banks, right? I remember one time, I think, John, you may have been with me when we were talking to one of the banks we were looking at, and they were telling us all of the things that they had done over the last year or so to improve their program, and they said they doubled their number of BSA personnel. And we said, really, how many do you have now? They said 2. so clearly, it sounded good, but not as not impressive. So same with banks. You have. Oh.
I think that was the same financial institution that had their AML policy still in the shrink wrap.
Right. So if you can't say you have an effective program if you don't have at least a certain number of investigators and experienced personnel. One other point I wanted to raise is economic citizenship when we talk about lack of political will, and clearly the issue of economic citizenship is one that makes it harder for us as banks to really identify higher risk customers. If somebody's coming from a high risk place, but then they're able to get a passport and citizenship in a place that doesn't appear is dangerous, that makes it harder for us banks to understand the risk they may pose. And this issue's been raised a fair amount in the Caribbean. And it clearly is an issue, but this study just came out a week or 2 ago and focused on countries in the European area, such as Austria, Cyprus, Hungary, Portugal, that also have economic citizenship programs. And I understand their motivations for doing that, sometimes economic. Nevertheless, programs like these just make our jobs harder and again facilitate the movement of illegal proceeds. So getting back to the list, obviously anybody who's been in this area for a long or even a short time knows that bank secrecy rules in certain jurisdictions are a major obstacle to identifying dirty money and investigating and prosecuting those cases. So Richard, what's the problem, and why can't we seem to overcome that problem in certain areas?
Well, I think actually just what you've been discussing. I think it's recommendation 9 now in the FATF requirements, even though they're called recommendations, says that there shall be no bank secrecy laws that will adversely affect the necessary acquisition of information. And I think that's pretty much what's happened. If I've looked through most recently the level of compliance on recommendation 9, pretty much most countries are now compliant with the law as written. But when it comes to actually implementation, that's a problem. And looking at the immediate outcomes, the IO so-called, which is now looking more carefully at the implementation of laws with respect to the requirements under the FATF, it's a problem because even though there is no law that says you cannot get information from a particular financial institutions just don't want to do it. And then you have enforcement in a particular jurisdiction, and they don't want to force the banks to do it, not just banks, but other financial institutions. So why is that the case? Well, because financial institutions want to protect their interests of their clients, and if they get a reputation for spilling a lot of information, that's just not going to be good for them. So exactly how you go back to the well and find a way of getting jurisdictions and the financial institutions to comply with coughing up information, coughing up evidence, I'm not quite sure. But I think it might make sense to go back and think at the very beginning, how do we motivate implementation of all of these rules? And it's not just bank secrecy. And there might be other ways of doing it. There might be ways of rewarding institutions or even government organizations for complying, not just punishing them when they don't. And that might be something that we want to, since we're looking at obstacles of success and how we can go forward and try to remove some of these obstacles, that might be one thing we want to talk about. But I'd like to raise one other issue here with respect to thinking of the Bank No Secrecy Act in the US and what I call the sort of fundamental or original sin, maybe, of our anti-money laundering policies, particularly through the Financial Action Task Force recommendations. And that is, number one, we say, we are going to adversely affect the profits of criminal activity by keeping them out of the financial system. It makes it a lot harder to use your criminal profits if you walk around with a big bag of cash. People might notice, people might steal it. So we keep that out, but at the same time, we want to bring this money into the financial system so that we can monitor it, find out where it is, follow the money, and then seize the assets. You can't do both at the same time. So maybe we should go back and rethink that as well.
I think this is a really, really key point, and a lot of countries are looking to what's happened in the US about keep open account procedures. And you know, Richard describes it as the original sin of the FATF standards, but it's a huge challenge from a law enforcement case. If they have prioritized an investigation, if they have suspects of interest and they know that entities are within a regulated entity and they're getting good reports on activity, the regulatory signals to you as regulated entities very often are to debank and to manage that risk, to understand and to keep risk out of your institution. From a law enforcement perspective, it's far superior to have that entity within a visible realm to get and continue to develop intelligence on that entity so that it can be taken to a prosecution outcome. So you have this huge divergence between law enforcement interests and the regulatory signals going out to the private sector. A lot of countries have recognized that, and they're now looking at how to put in place keep open account procedures where effectively the regulator can provide some comfort to regulated entities that they will not face what they would have expected in terms of enforcement compliance obligations. For cases where law enforcement have said there are suspects of interest or persons of interest or entities of concern at play. But it just shows the real tension between the regulatory signals set up for the regulated entity and law enforcement priorities, who are the ultimate customers for this information.
I will just say, I run a program, it's a Master of Arts in Anti-Money Laundering, and we have people from the regulated side, the financial sector, investigators, prosecutors. And when you ask the question about this fundamental original sin, all the investigators, prosecutors, folks who are trying to recover assets say, get everything into the financial system. What about you folks from the financial sector? Keep them out.
And ultimately, I mean, the system has so much inefficiency and ineffectiveness almost hardwired into the system. So the signals out to a regulated entity to debank a suspicious customer, well, a huge amount of cost might have gone into that decision and very likely went into that decision. An investigation internally, all the KYC processes, all to result in that customer simply being debanked and perhaps being able to re-enter certainly the global financial system and in many cases the national financial system at a weaker point. So despite all that cost, the main result is a displacement of risk to a more vulnerable institution. The fact that, and we'll come on to private sharing, that entities in many countries, the US is almost unique in having the legal ability for private entities to share information about suspicions. Private sector entities around the world aren't legally allowed to do that. They can't share information about who's been debanked, they can't share information about suspicion, and therefore suspicious customers can simply re-enter the system at a weaker point. And that's hardwired into our system in many countries.
All right, well, and we're going to get into information sharing in a second. And by the way, if we'll try to save some time at the end for questions, but if anybody has a question or comment they'd like to make, please feel free to ask them, look for the microphone and do so during the presentation. We're happy to take any questions or comments. But the next subject, which you also drew the straw on, Richard, is another tough one and one of the toughest, and that's the ease of formation and lack of transparency for corporate entities. And obviously that makes life harder again for banks, for law enforcement, and for tracing the dirty money. So another very difficult issue.
And actually, I will share this, I should, with Nick, since Nick knows quite a bit about this topic. Starting initially, I used to teach business associations, partnerships, limited liability companies, trusts, trust-like relationships, and the truth is, it is going to be always very difficult for anyone on the outside to find out who the beneficial owner and controller is of any kind of company, any kind of trust or foundation type relationship. They're set up that way. They were designed to make ownership, at least with respect to companies, to separate, and trusts, separate ownership and control, and to make it easy to have some ownership changes without changing control. That's why we have companies in the first place. It's easy to change, to buy and sell stock. That goes back hundreds of years. So by definition, this is always going to be something very difficult to determine who is the current owner and controller. I think, again, we need to go back to that fundamental issue and say, why are we concentrating so much, particularly through the new CDD requirements in Recommendation 10, and also, of course, in the US. The Recommendation 24 and 25 with respect to requiring countries to make it easy to identify the beneficial owner and controller of entities that we already know by definition are very difficult to determine who the owner and controller is because they were set up to be able to switch these things very quickly, switch the owner and controller. So one is looking at the customer due diligence side so that financial institutions can, when they onboard a customer, know a little bit more about who the actual owner and controller is of a particular account. Why do you do that? Well, you know, if it's a bad guy, then you don't onboard them in the first place. Maybe you file a SAR or an STR. But even more importantly, I think, is in order to conduct monitoring of transactions, you need to know a little bit more about the customer to see whether the transactions fit the customer's profile, something that looks out of sort with respect to what we know about the customer. So if Richard opens up an account, he's a poor law professor, he gets a little bit of pension from the IMF, my transactions would be different from if I open up the account on the benefit of somebody else, and it turns out that, oh, there are billions, well, millions anyway, coming in and out of my account, going back and forth to Latin American countries, European countries, that just doesn't seem to fit with whom I claim to be. So those are the two reasons. Keep bad guys out at the beginning and then be able to monitor transactions to see if they fit with a customer profile. Do you really need to know the beneficial owner and controller for either one of these? And I raised some questions. With respect to CDD, maybe you don't. You just need to know if Richard said you show up and Richard is the person who opens the account, and you ask him, are you the beneficial owner and controller of this, or say it's a company, and I say yes. You can do the same thing, right? Gee, why does somebody like Richard, he owns this account, says he does, or it turns out he says his cat or his dog owns it or something. And yet, this does not fit with the profile of who Richard claims to be. And I come in and say, well, that's because I'm a brilliant intellectual property person and I've come up with something that show us, prove it to us. So it doesn't really matter whether I own it, it's the fact that I say I own it. It doesn't really matter whether my cat owns it, it's that I say it, and then that profile does not fit with my transactions. Ditto, actually, I think, in customer onboarding. When it comes to law enforcement, again, it's really, really difficult to determine, even if nobody lies, but I'm guaranteeing to you, I think, that criminals will lie. It just happens. It's hard to, I know, it's hard to accept, but they do. And as we've had more effective proceeds of crime laws around the world, and actually, if you look at the Panama Papers too, in the old days when you didn't have effective proceeds of crime laws, sure, then criminals were perfectly happy to have a real legal entitlement to either controlling or owning the beneficiary of a legal person. Now that we do, they're not going to do it. I mean, we had one of our last capstone project for our Master of Arts course. And I said we had people from banking community, regulatory community, and law enforcement as students. And they were given a set of circumstances, set of facts, and said, now you're the launderer. What do you do? And everybody agreed, step one, don't own anything. Have somebody else own it. So there must be a more effective way of being able to seize assets, trace and seize assets, without having actual ownership. And I think that the UK, Commonwealth, I'm from the Commonwealth of Massachusetts, but I mean the former British Commonwealth, have more effective proceeds of crime laws than, I mean, the US really don't have one. But that's looking at things in a different way, rather than just saying, who really owns and controls? Well, it's probably not the person who actually owns and controls. So, I mean, has the legal title. Because after all, what does it mean to have legal title or a legal right? It means you can go to court and enforce it. I'm thinking Putin probably isn't looking forward to going to court to enforce his rights. Lula, not saying that they're guilty of anything. I'm just a professor, so I can throw these hypotheticals out. So you need more effective ways from the law enforcement side. And to go back to CDD, I think what we've got might be enough, because it just allows financial institutions to look and say, what the person they say owns and controls it, does that fit the profile of the transactions?
Yeah, I mean, as anyone with law enforcement experience and private sector experience in this space will know, corporate secrecy and layers of corporate structuring are ubiquitous in cases of money laundering and corruption. And it doesn't even take professionals to know that. I think if you watch, I'm a big crime Netflix binge watcher. And if you know any of those series, whether it's Narcos or Peaky Blinders, right, going back to the start of the century, it's a very, very common method for criminals to use to hide ownership of assets and frustrate investigations. I think this is an area, I mean, we can get a little bit drowned in sorrow sometimes in these debates, but it is an area where we do see some progress. So in the UK, there is a commitment and the development of a public register of beneficial ownership for all companies established in the UK. I think perhaps more excitingly, there's a commitment for property that's held by a company, whether it's foreign or domestic, to declare their ultimate beneficial ownership. Now, Richard's absolutely right. We don't expect criminals to tell the truth, to suddenly start declaring, but the point is, when there's a legal obligation to report and someone has put their name down in the form, from an investigator's point of view, you have a start. They probably already have their suspicion about the use of a property or an asset in an investigation, and if they know and they can prove that someone's lied in that obligation, there's now a criminal case that can be made against that individual for lying about their ultimate beneficial ownership, and it's a start point and it's more leverage for the investigation. In Europe, we see the development of the AML directives. We're now on talking about 5 and 6 AMLD, if you're following that in Europe. And there's the move to allow entities with a legitimate interest, which could be defined quite broadly, to have access to national beneficial ownership registers. And we see countries in the LATAM region looking at beneficial ownership issues at the national level. So I think it is an area where we see some policy progress, some policy movement, and obviously from a regulated perspective, when you're obliged to discover the beneficial owner, and even law enforcement can take years to unpick layer and layer and layer of company secrecy, it's an impossible challenge in many cases for regulated entities.
Thanks, Nick, and we look forward to seeing how those new measures will work out in the UK. David just brought to my attention the fact that the UK has created a new tool for law enforcement involving unexplained wealth orders. Could you just tell us a little bit about that?
Yeah, absolutely. So prior to working with the Royal United Services Institute Centre for Financial Crime and Security Studies, which is this most recent paper that I'll be talking about shortly, I led the research function for Transparency International UK. We set up a task force of major stakeholders from banking, from the legal sector, from the accountancy sector, from academia, to really look into this issue of unexplained wealth. In Australia and in a number of other countries outside of a common law tradition, particularly in Latin America, there are powers that provide the state with an ability to approach suspects of concern with a certain threshold of suspicion and ask them to explain, compel them to explain sources of wealth. Now, in many ways, there are legitimate concerns about presumption of innocence, human rights, civil liberties around this. We held a task force to really get into those issues and look at the effectiveness of how it's been deployed and various legal interpretations of how that would be implemented in the UK. And eventually, we published our study really borrowing on the Australian example. Australia has been fantastically successful compared to other common law countries about recovering the proceeds of corruption, proceeds of crime, and particularly narcotics, through their laws. So much so that the Australian criminal sector now sells information because they have become so finely attuned to evasion to avoid some of these powers. But that's part of the arms race. Unexplained wealth orders basically mean that in the UK, if they have achieved reasonable cause to suspect that an asset over a certain threshold of value is the proceeds of serious crime or corruption, that they can serve an order, a civil order, on that individual to explain their sources of wealth for that asset. If they fail to do that, or if they can be proved to be lying in their response to that, UK law enforcement can take a civil action, not a criminal action, against the asset to support a proceeds of crime recovery action against that asset. The civil burden of proof is reasonable cause to believe, not reasonable cause to suspect, not beyond reasonable doubt. So, which is the criminal test. So it's very early. The new power is being looked at with a lot of interest in how the National Crime Agency in the UK first use it. Will they go for the big strategic cases? We've seen all the property in the UK. There's a lot which you might have reasonable cause to suspect. Or will they go for low-hanging fruit and really get some case law, some precedent around some of the more bog-standard, we might call criminal groups in the UK?
Richard, did you want?
Yeah, I think this is incredibly important, and I'd just like to make a distinction again. If you have an unexplained wealth law, I think even more likely the seriously very high-end corrupt officials will not own anything. They will not even have legal title to anything. Even 100 different companies, you'll find that they don't own it. What they will be doing is enjoying the benefit of it. Again, the suggestion coming out of the Panama Papers again is that Lula does not own anything, but he lives extremely well. The former president of, recently convicted of corruption in Brazil. The same thing with Mr. Putin. I always forget, is it his friend, the violinist or the violist or something, who owns everything? And he doesn't, but he lives really well without having any legal title, even indirectly through layers and layers of companies. But what in the world is a violist, I think it's violist, doing with billions in assets? Unexplained wealth there. What about Lula's friends? Unexplained wealth there. And if you're an investigator and prosecutor, you might want to follow what benefits a potentially corrupt individual, government official, what benefits that person is enjoying from friends and associates. I mean, you just have to go back to the first Godfather movie. I mean, if you, let's face it, you don't own it, somebody else does. You used to be called a straw or a frontman. So.
And I think there's not just that top, world-class corruption, if you like, but there's a big tier of public officials where there's publicly available information on the amount that they should be drawing in their public income, and perhaps the transaction that might be passing through your visibility as a regulated entity. So if a military general, on a wage of something like $50,000 from some developing country is passing through 20 million, when you're filing that report, that's the kind of information that would be used as a basis for not just that information, but part of the investigation that might go into an unexplained wealth order. So that's how your detection and identification of suspicion might feed into that.
Well, again, we look forward to hearing how that's going to work out in the UK. Let's move on to the next two topics, which are ones that you've obviously done a lot of work on, Nick, and in your report you raised. So why don't you talk a little about limitations on information sharing?
Yeah, absolutely. So within the FATF standards, there has been a provision and guidance that FIUs, financial intelligence units, should provide feedback to the regulated sector to help them better understand risk, to make risk-based decisions. But in the past, in many, many countries, that's been very, very limited. It's been very difficult to achieve public-private information sharing in a financial crime space. However, again, it's a story that's changing. And in the last few years, we're seeing real innovation in a number of countries about how to support public-private partnerships to share information. Here in the US, there's been the longest standing legislation to support this, coming through from the Patriot Act in 2001. But it's taken a lot of time for stakeholders to think about how to exploit that legislation, how to use that legislation to get over trust issues between the private sector and between public and private sector to start to really take on the opportunities of that legislation. Some of that has been spurred by innovations in the UK, where the Joint Money Laundering Intelligence Task Force was created. The idea is to bring together the major regulated entities, the major reporting entities, with the law enforcement, FIU, and regulator to come together and to talk about different perspectives on financial crime threats. Different people are seeing a different part of the problem, and coming together really to produce two kinds of outputs. One, co-developed, public-private, co-developed typologies of risk for specific financial crime threats, drawing together the insight of investigators and the regulated sector, and then producing typologies and indicators that can then go back to the private sector regulated entities to enhance their indicators and suspicions. And then where the legislation allows, partnerships have been going further into operational information, such that persons of interest, entities of concern, can be shared in a secure environment with often a vetted group of individuals from the private sector under a memorandum of understanding about how the information is handled and shared, such that the banks can then go and be more directed in their internal investigations and be producing suspicious activity reports that are more relevant, more timely, more useful for law enforcement investigations. We published just at the end of last year a major study backed by industry. So our global sponsors are HSBC, Western Union, EY, and Thomson Reuters. But a wide range of public agencies have engaged in the research here in the US, in the UK, in Australia, in Canada, in Hong Kong, and Singapore. And we really looked into the partnerships that have been developed in those countries and presented that to FATF and Egmont Information Exchange Working Group tail end of last year. I think what's so interesting is that they're all being taken forward in a real spirit of innovation. Often leaders from the law enforcement sector have come into private sector financial crime control roles, FIUs or financial crime threat mitigation, and have had a close awareness about what law enforcement are struggling with, because that was where they were formerly working. And they've said, look, we have data here, we've got more data about suspects and concerns, a bigger picture of a network analysis, how they're behaving, than we can file to you through the current legal systems. We need to find a way to give you this more comprehensive picture of risk on suspects and networks, both nationally and internationally. And there's a lot of innovation in countries about how to do that through these partnerships And our study is publicly available, the Future of Financial Intelligence Sharing website within RUSI, which is a think tank, the Royal United Services Institute, and the effectiveness indicators are quite promising. Arrests, asset recovery, all supported in these jurisdictions. I think some of the challenges are the rate of cases is quite low, particularly in the UK and Hong Kong models. It resembles more of a case briefing. So law enforcement provide a briefing to a secure room, and then those individuals go to their institutions and run those checks. So it's very low tech. In Australia, there's some real innovation with co-location of public and private sector analysts who are sitting together, and the aspiration is to develop shared analytical systems and aggregated data from the public and private sector to run searches both for cases and for typology development, and then have that support law enforcement outcomes and support risk-based decisions in the private sector. A lot of challenges: technology, regulatory alignment, regulatory comfort. Is there political comfort for a much more enhanced level of sharing that could actually mean that suspicious customers can't enter the financial system and are effectively denied financial services due to suspicion alone outside of a judicial process? The increase in effectiveness is really bringing to the fore some of these questions, but these partnerships are certainly driving on the effectiveness agenda.
Yeah, thanks, Nick. I think this is one area where there really has been some progress, and there's really, I think there's a lot of room for optimism here about law enforcement and financial institutions working together, building up that trust that we can be partners even in investigations at times. Some of it is industry initiatives. In this country, we have some initiatives of banks working together under 314B to try and work more effectively, and a lot of use of 314A. FinCEN, Andrea's not here, oh, there she is, has been very creative in developing some new methods of information sharing that are more effective, so we commend them for that. So I think it's an area we can really look for some positive developments. The next item, I'll call on you, and also John from his Department of Justice perspective. A big frustration for banks international banks is the difficulty in sharing information cross-border, and of course for the Department of Justice and investigations, getting information from one country to another through mutual legal assistance treaties. So we just, and clearly the criminals have an advantage here. They don't have to follow all these rules and regulations whereas law enforcement does. So why don't you just briefly touch on that, Nick, and then John can discuss it from the DOJ perspective.
Yeah, absolutely. So it's the classic problem that criminals are highly adept at information sharing, cross-border, nationally, and highly networked. And our public response is really constrained by our national boundaries and our national legislation and our national law enforcement efforts. Egmont and FIUs work really hard to support information sharing between FIUs and support mutual legal assistance, but very, very slow and cumbersome process, mutual legal assistance. From a bank perspective, and I think these partnerships have been helpful in really bringing this to light, international banks can often see the links between suspicious customers, but for certain jurisdictions can be forced to break that apart, to break apart the international picture and just file a suspicious activity report that relates to national activity. In some cases, they're not allowed to tell other jurisdictions about suspicions originating from data in jurisdictions where that information isn't allowed to be shared. So they have to really take apart an intelligence product, which they can see in full, and file it to different FIUs in the hope that they put the pieces together. Now, obviously, we might have concerns about the ability to put that piece together, and there's a lot of work going on at the FATF level to really understand how the standards, guidance, and legislation could be improved to support cross-border information sharing. It's recognized as the real Achilles heel of our public sector response. I think one to watch out for in particular is the Europol financial information sharing partnership. So that's really the first transnational version of the public-private partnerships that we look at. What they're trying to do is, even in Europe, which has some level of regulatory and legislative harmony, still very, very difficult to do cross-border sharing. So the Europol partnership is trying to achieve the same kind of operational outcomes that FinCEN Exchange, that GIMLET, that Australian FinTel Alliance have achieved at the national level. But they're also going to be reporting and documenting all of the legislative and national legal barriers that prevent them from doing what they would consider to be effective in building these intelligence products.
Yeah.
And John,
It's
from
just,
the DOJ
I mean, just
perspective?
briefly, because I know we want to leave time for questions, but this is an enormous challenge that, in the 21st century, it's a global financial network. But as a criminal investigator, my experience is once you understand that the funds are flowing overseas, and really anywhere overseas, you've just added a year to your investigation. So in any kind of a fast-moving investigation, you've really hit a roadblock, are forced to disclose elements of your case which you may not want to have to disclose for operational security reasons to unknown individuals in another country who may be very well hostile to what it is that you're trying to do. So to me, this is the single biggest barrier in sort of international money laundering investigations, is this idea that there's very, very poor cooperation. It's a highly formalistic process that frankly doesn't give much benefit.
All right, thanks. On the issue of cross-border information sharing for financial institutions, of course, folks know that U.S. based banks are unable to share SAR information with their foreign branches. I know this is an issue that FinCEN is looking closely at and looking for some solutions. So this is an area, again, where I think there's possibility for progress on breaking down that barrier. So we got about 15 minutes left, a couple of more topics, and of course we're happy to take questions or comments at any time. But this was a big one for me, Richard, the failure to include attorneys and real estate brokers under AML regulation requiring customer due diligence and SAR filing. Why don't you just give us a little bit on that?
And also the wonderful term DNFBP, Designated Non-Financial Businesses and Persons. The idea is to bring in folks who are not financial institutions to do customer due diligence and transaction monitoring and suspicious activity or transaction report filings. We all know where this comes from. It makes, particularly with the examples that you are giving, first less. Banks have to know their customer, but they may not know as much about their customer as the customer's customer. And we often see that lawyers and real estate agents are involved in money laundering transactions, so why not extend the rule from banks to them? That's what the FATF requires when you have a mutual evaluation or an assessment of compliance with the FATF recommendations. If you don't include lawyers and real estate agents, particularly lawyers, and many of us are lawyers, I feel particularly picked on because of this, but if you don't include them, you're going to get your hand slapped. You're non-compliant, your IO is going to be unimplemented, but let's sit back for a second. I mentioned The Godfather, #1. Remember Tom Hayden, those of you who've seen? He's the consigliere, come si chiama in Italiano, the advisor, the lawyer to a crime family. Do you think he is going to do customer due diligence and file a suspicious transaction report on his client? I think not, because he's going to be a conspirator. How many lawyers are there in the US? It's something like 2 billion. I didn't count the exact number. Real estate agents, it's like twice that. So why do we know that financial institutions are likely to follow their requirements? Because they are are participating in compliance examinations. You all get examined. You have FinCEN, who has some of their agents, OCC, et cetera, come in and do it for them, but they come in and breathe down your neck. Are you doing this? Is this ever going to happen to lawyers or real estate agents? I don't think so. So the question is, what are you actually going to get some benefit from this? Now, I'd like to go back to the politically exposed person issue. sorry about the joke, but it actually is true. I had a raincoat and I did this. I said, we don't want to do that. There are unintended consequences when you start piling on rules. What is the principal unintended consequence of politically exposed persons requiring this under Old Recommendation 6? Okay, we have people who are corrupt government officials, so let's make banks find out if they have a corrupt government official as a client. Have enhanced due diligence. So guess what? Corrupt government officials did not identify themselves. They had somebody else come in. They had their straw. They had their agent. They had a company. Whatever they did not identify themselves. Who did identify themselves, who actually were PEPs? Honest PEPs. The corrupt PEPs didn't, the honest PEPs did. What happened to the honest PEPs? Well, they're probably not very wealthy, so they got de-risked. Because why? It's more expensive for a bank to have on board and maintain a client who's a politically exposed person. So what do you have? You have all these people who lose their bank accounts, but not the actual, who are honest, but the dishonest ones don't. Now, if something like this could happen, again, at least the law of unintended consequences might happen if you bring in lawyers and real estate agents. What might that be? Well, number one, it could be that all the honest real estate agents, all the honest lawyers actually go through this process, and of course they have no criminals who come to them for services. So what do? You have expenses go up, then you have to have people who go out and try to make sure that these folks, they're not going to be supervised, but at least somebody's got to take a look at them. So assets, human assets in particular, that could be used to find bad guys in some other way are going to be allocated to showing that honest lawyers and honest real estate agents are being very good about their honest clients. Not going to help very much. I don't know if that's the case, but I think that that's quite likely. So is that a wise pattern to follow? And to me, it goes back to, fundamental principles when anti-money laundering rules were conceived. What are we trying to do? Again, keep bad guys out of the financial system or put them back in so that we can identify them, follow their transactions, identify perhaps when they're bad guys, and then report that, and then have law enforcement go after them. Go back to fundamental principles, or should we keep, there's a leak that pops up in the pipe, and so we stuff that, oh, lawyers are involved, so we're going to extend this previous rule for financial institutions to lawyers, but it's a different situation. Lawyers are not subjected to supervision. They're not subjected to this kind of intense regulation. So then, oh, that's going to pop out because it's not working very well, so we get more chewing gum, and then we apply glue, and meanwhile, everything's coming out the bottom. So maybe in this case, I at least suggest that there might be some other way of proceeding with designated non-financial businesses and persons, which includes not just lawyers and real estate agents, but folks who don't have that kind of political power, like precious gem dealers, for example. And rethink how we want to do this. Maybe we should just tighten the laws, one might say, make them more applicable and more harshly applicable with respect to conspiracy. So yeah, you want to catch the horrible real estate agents involved in placing criminal proceeds in the cases that Les was talking about. Let's go to that instead of pretending that they're supervised. They're not. But
Thanks,
that's
Richard.
just my opinion.
Yeah, I'm not optimistic. When we were at the Department of Justice, some of us thought that lawyers could be included in the SAR filing requirements to the extent that they're engaging in transactions and not the representation of clients in litigation, but I don't think we'll ever overcome that. I am more optimistic on the real estate side. FinCEN has clearly been taking an interest in the real estate industry through their GTOs, and I'm hoping that will lead to some sort of regulations to bring them within the fold of filing SARs at some point. These last two topics I'm going to take a quick run at. I saw this study by the Miami Association of Realtors recently, and I was shocked to learn that a lot of foreign people are buying real estate in the Miami area. So this brings up the issue of capital flight. Clearly, folks know that there's a lot of Russian money coming into Miami, a lot of Venezuelan money coming into Miami, purchasing property. Capital flight is an interesting issue, and I remember discussing this with Clemente when I was at the Department of Justice. Rest in peace, Clemente. And every year I would come down and he would ask me, what are we supposed to do about capital flight? Should we If we know the people and they're honest citizens, but they're violating the foreign law and bringing the money to the US, should we file SARs or not? And I would say if it's suspicious, file a SAR. But I think that's not the point. I think the point now that I see is what is the US government's position on capital flight? Obviously, it's good for the US economy. It's good for the real estate industry to have foreign money coming into the US. We want innocent people in repressive governments like Venezuela, the honest people in Russia and other countries who are trying to get their money out. We welcome that. The problem for banks is how do you distinguish the money, right? You see it's coming from certain countries. We can't go into those countries and figure out what's going on often. They're often opaque. So what do we do? How do we make those distinctions? And you know, I think I don't know that there's an answer. I think it's a discussion I'd like to have with the government to see what their position is, to see, you know, is capital flight a good thing? If so, let's discuss how we can distinguish the good from the bad, because I think it's a very difficult issue for us. Interestingly, there was an article I saw on the internet yesterday that the headline was, "After Spy is Poisoned, Britain mulls closing door to London for Russia's rich." And it said, one possible countermeasure could involve denying Russia's so-called oligarchs access to the luxuries of London, where many have channeled their fortunes, traded their companies, and relocated their families' lives. Now, some of these oligarchs came about their money honestly, maybe, and many others did not. Up until I saw this article, London seemed to welcome all that money purchasing London real estate. Is this now going to be changed maybe in how we look, or how London, UK is going to look at this issue of capital flight, and is it really desirable or not? So again, a difficult problem, but I think it's worth a discussion between the banking community and the government. And finally, and this is kind of lead into the next panel, I think Annie will ask some questions about this, the lack of regulatory flexibility for innovation. And you heard David's discussion with Ken Blanco yesterday, the FinCEN director. It's hard to change the system, and it's hard to change the regime. What I've been kind of advocating recently is let's try things on a pilot project level, right? We're not going to change, you know, it would take us even if the government agreed that we should change the SAR filing system for structuring SARs, low value structuring, it would take 5 years to implement that, right? So let's try it with one bank for 6 months. Let one bank try just automating their information flow to the government in low value SAR filing cases, if it's even possible. Maybe it's not, but let's try that. Let's see if it works. Otherwise, we're never going to know if something works if we wait for the whole regime. Should the threshold be raised? Should it be lowered? These are things that are difficult to change systemically. So let's try a project. Let's try innovative projects. In my view, that's the only way we're going to ever move forward with some of these issues. I think, and Andy will probably pick up that discussion on the next Ask the Regulators panel. So with that, we've come to the end of our list. Happy to take any questions. And if not, I'll just ask each of our panelists to just briefly sum up and give us their most brilliant point they can think of to close off the panel.
Oh, that's too big a challenge. No, just picking up on your last point about innovation, and we're looking back over quite a long stretch of time, and you know, there's a lot of cause for concern about effectiveness, about efficiency, but there's also a lot of cause for optimism in this space of innovation. I think what FinCEN has started recently with the FinCEN exchange, the support for getting more out of private sharing here in the US through 14B, potentially very, very exciting, and a model that could be explored and potentially investigated from a research point of view, and then adopted, considered in other countries. We're going as a program to Argentina just next week, where there's a very exciting program of legislative reform looking at public-private information sharing. Last year we were in Mexico, where there's some very, very interesting work on private sharing and single KYC utilities, and that's just in this region. Outside of the LATAM and Americas region, there's a lot of innovation, and I think a lot of it is being driven by these public-private partnerships, because leaders from banking, regulators and law enforcement are getting together, and they're really thinking about effectiveness, almost in parallel to the existing compliance-led regulatory system that we have. So I think we're seeing some exciting developments, national and international.
All right.
Les is clearly tech challenged there, so I'll just jump in. I mean, I think context
I
here
missed
is
the
important.
questions. I apologize here.
Context here is important. There's trillions and trillions and trillions of dollars moving through our global financial system at any given time. The idea that you're going to be able to pick that needle out of a stack of needles is, frankly, almost impossible. So I'm not particularly comfortable with sort of the counterfactual, but what would happen if there were no money laundering regulations? I think we'd be in a far, far worse place. So I'm actually, notwithstanding my opening remarks, somewhat optimistic about where we are. I came to this conference, the FIBA conference, I think it was in 2004. There was about 120, 130 people there. Now I came back and it's 1,400 people, so it's a huge difference.
And I would say, in looking at innovation, go back to the original purpose for having anti-money laundering laws in the first place, which is to reduce the incidence of crime, including by catching bad guys and grabbing their assets. So go back to first principles and rethink. Don't keep going back to what kind of statutory, theoretical, really, structure that we have now, and that includes internationally through the FATF recommendations. Keep going back. How can we catch bad guys? How can we reduce the incidence of crime? And in the process, now that it's 2018, God, where does the time go? We have this thing called artificial intelligence and evidence-based artificial intelligence. And actually I think part of information sharing is the more information that we get, the more effective from the preventive measures side we can make our typologies of understanding how bad guys launder their money, using evidence, trying it out. If it doesn't work, we try something else. But go back to principles, think about evidence-based, how we can use artificial intelligence to implement evidence-based anti-money laundering, and try to catch those needles in the needle stack, particularly the people who have them, I suppose. Yeah.
Thank you. I'm sorry I missed the questions. We did have a few. An interesting one says, it seems that in the conference all the speakers talk about the same thing, not enough is being done. I think here we tried to look at some of the issues as to why things aren't being done and propose some ideas for moving forward. It also says, interestingly, is the war against money laundering the same as war on drugs? Is it just a hopeless situation, or should we keep trying to stop it? I think in this respect, I think there is more promise in trying to counter money laundering, because yes, with the war on drugs, people are going to want to use their drugs, and it's always hard to stop it. In this area, yes, people need to launder their money. There's always going to be criminals that try to launder their money. But I think we've seen a lot of progress has been made, even though the situation is still disturbing. I think over the years, the fight against money laundering has helped to strengthen our financial institutions, made them more conscious of what they're doing and understanding of how they're operating. And I think the partnership between the government and the private industry has been a great one in strengthening our financial system and making it harder for the criminals to launder their money. So I don't think it's hopeless. I think it's a worthy endeavor, and conferences like this will help us continue to make progress. So I'd like to thank my panelists for joining us today. Please give them a hand.